A continuación vamos a oír a Ben White, que es jefe del Departamento de Propiedad Intelectual de la Biblioteca Británica, como he anunciado antes. Ben cuenta con una cumplida experiencia en el mundo editorial, habiendo trabajado para Pearson Education International y también para Ordnance Survey, una especie de agencia estatal de cartografía. Es muy activo en materia de propiedad intelectual, habiendo formado parte de los consejos asesores en esta materia en diversas organizaciones e instituciones como la BBC o el Instituto de Investigación de Políticas Públicas. Actualmente, además, es el portavoz del Grupo de Trabajo de Copyright de la Conferencia Europea de Bibliotecas Nacionales. Pues adelante, Ben.
Thank you. First of all, I'd like to say thank you very much to the Ministry of Culture and also to the National Library of Spain, which I have to say is probably the most beautiful of all the national libraries I've had the pleasure to visit. I also am very conscious of the fact I'm keeping you from coffee. There will be some pain before you get coffee. I'm a minority in an international conference. I'm a native speaker of English, and to make it worse, it's British English, not the lingua franca American English. So, and I will also use Latin in my presentation, so it will be miserable. This is some examples of what the British Library have done. We've really sort of skirted around the edges of copyright in our newspaper projects and our book digitization projects. The oldest known item in the British Library that is in copyright is a poem from 1862. So although this is on the borders of copyright, there probably will be in copyright material in the first two projects, and certainly our 2,000 days worth of sound recordings that we've put on the web have recordings going up to the last couple of years. I will give you some examples of the types of things that we're digitizing, as well as some examples of orphan works. This is an oral history project we interviewed in the 1980s, many British jazz musicians, and we had their addresses. We got permission forms at the time of recording, and 3 years ago when we wanted to put this up on the web, we could not find 26.5%. So within about 20 years, about a quarter of the people had disappeared. This is unique material. The previous speaker said, a lot of what cultural institutions want to do is put material that isn't necessarily mass-produced from the entertainment industries. This is an example of a beautiful hand-illustrated book, unpublished, from the Second World War, from the Women's Institute in Dorset, unpublished. Nobody knows who produced the book. And we've digitized it and put it on the web, so that work is essentially an orphan work. This is something this is an illustrator that's actually managed by the Victoria and Albert Museum in London, Marcel Fromenti, French. According to the Victoria and Albert Museum, this is an orphan work. They know his death date, but they cannot find any heirs. And again, another oral history project. This is from the Institute of Contemporary Arts in London. We spent 1,800 hours looking for rights holders. Interviews from 1981 or discussions from 1981 up until 1994. Something like 1,629 rights holders. Derek Jarman, the famous British director, was one rights holder. Malcolm Bradbury, Jacques Derrida, and lots of people you haven't heard of. So as I said, we spent 1,800 hours, nearly double the time of the 1,000 hours, looking for 1,700 rights holders. We contacted 1,200. So about 500 we couldn't find, and we got responses from about 1,000, which I have to say is extremely good. So the evidence base, there are some examples. Sound recordings, depending on the material. I think modern published material will there will be very few orphans indeed. The kind of sound recordings that we have some very high statistics of orphans. And I think the Carnegie Mellon University study is very interesting in the States, which says that of published books, that 31% of the books in the project that they undertook, which was something like 250 books, about 31% of those were orphans. And of course in the States, the public domain starts or goes up until 1923. There's also a history of registration. So I think in Europe, and we don't know, which is why as part of Arrow, we are about to do a study. As we go back further in time, there may be higher levels of orphans. So in the UK, turning to legislation, we actually already do have a very small exception in UK law for orphans. The material must be pre-1989. It is reasonable to assume that the author has been dead for 50 years and the work is older than 100 years. A very small exception. So what we have tried to do, and at the end I will try and summarize why this clause 43, failed in the Digital Economy Bill 2 weeks ago. We've tried in the United Kingdom to introduce sort of a Canadian-style licensing system for the management of orphan works. The proposal, clause 43, I'm using the numbers because they changed as the legislation moved from the House of Lords into the House of Commons. There was a lot of debate in the House of Lords, so I'm using the kind of updated clause numbers and section numbers. It was not limited to education and cultural bodies, and it was not limited to non-commercial use only. And the idea was that it would provide for a licensing body or other person to do or grant licenses to do acts in relation to an orphan work. So what does that mean? That means that effectively somebody would have to apply to the Secretary of State to either use an orphan work themselves or perhaps get the right to essentially onward give permission for a third party to use an orphan work. So, for example, a collecting society would be able to apply to the Secretary of State for the permission to onward license orphan works, subject to certain provisions. And I will quickly go through the provisions. And this is primary legislation, so a lot of the detail was to come in further regulations. So the regulations will provide for deduction of administrative costs, period for which sums must be held, how to deal with the money. This is the Latin that I referred to earlier on, bona vacantia. That might be a uniquely British system of dealing with ownerless goods. Mainly it comes from treasure and assets that are left in a will, but there are no heirs. So in the UK, there is this scheme which is operated by Her Majesty's Treasury, which essentially deals with these ownerless goods. And again, this was not saying that would be the system for dealing with the money, but it is given as an example in the proposed legislation. And for regulations would also set onward obligations and regulations for those that receive the permission to use orphan works or sort of onward give permission for the use of orphan works. And also, of course, if an orphan works owner turns up, the regulations would deal with how to deal with such instances. So what comprises an orphan work? We've heard this many times before. A reasonable or a diligent search would have to be undertaken. And we would have to, in a publicly available register, have to put why, what steps had been taken to look for the rights holder. Again, this is a non-exhaustive list, but the proposed legislation says that the search must be reasonable, and bodies to go to or schemes or systems that can help are the licensing bodies, the collecting societies, associations of creators, authors, publishers, other databases, library catalogue, and public available material. And it also made the point, because a lot of the collections that sit in national museums, the National Library, and in universities are international, that this activity must relate to the country that one believes the object came from. So section 116D went on to say that regulations would give more details of the register. The register would be publicly available. There would be information around removing the work, and it would also outline diligent search steps. I think, interestingly, it did allow for instances where you were aware of another party having gone down this path and spent time looking for rights holders. So if it is known already to be an orphan work, then the legislation provided for not having to repeat that due diligence process. So why did the clause fail? It certainly had a broad coalition of very vocal supporters from the museums, the libraries, the BBC, the collecting society, trade associations, universities. As I said, it was only 2 weeks ago that it failed, so I think history will give us the answer. Certainly the most publicly vocal groupings were the photographers. And the photographers, again, are not a monolithic group within that lobby, and I know one of their sort of chief lobbyists personally very well. There are differences of opinion within the photographic world as to why they were uncomfortable with the proposed legislation. So they certainly highlighted issues that within the bill, the clause on orphan works was in the same clause as extended collective licensing. If you look at the British Association of Picture Libraries Association's website, you can see statements where they're concerned that extended collective licensing will perhaps preempt their ability to onward license, enter into exclusive license agreements. So there was a certain level of discomfort there. They felt that the bill, certainly as it started, I think it improved as it went through the House of Lords, was weak on the issues of attribution, and they wanted stronger protection of metadata that travels with digitized objects. And I think number one is also very important. We have an election on May 6th, so although there was full debate in the House of Lords, there was not time for full debate in the House of Commons, and the bill hit up against a process known as wash-up, which is where essentially the whips and the party leaders agree with the government and amongst the opposition which parts of a bill will fall and which will go through. And the Digital Economy Bill, the name of the bill that it was in, had many different aspects to it. Only one was orphan works and only one was extended collective licensing. It also had, it's also the three strikes legislation, the Hadopi law that's been introduced in France, which is the most controversial part of the bill. So essentially we hit wash-up and the clause was removed. So thank you very much.
Muchas gracias.